Hello, my name is Alex Proctor. I am the Chief Trust and Privacy Officer at Captain Compliance. It is the last day of July in 2025, and for the second time this month, we have a new state privacy law that's gone into effect. This time, out of the North Star state. Minnesota is now the 15th state with an active, comprehensive privacy law. Originally passed in May of last year, the new law is called the Minnesota Consumer Data Privacy Act, or as we'll call it, the MCDPA. I have to say, this is just the perfect acronym because we also have the Montana Consumer Data Privacy Act, which went into effect last year. Now, I think that one is supposed to be called the MTCDPA. I don't know why Montana didn't get dibs on the shorter acronym, and I'm sure this won't lead to any confusion whatsoever. Anyway, in this video, I'm going to be sharing what you need to know if your company operates in Minnesota. I'll draw some comparisons with the other state laws, especially Tennessee's, because that was the other one to go live this month. By the way, I did do a similar video for the Tennessee law earlier in the month, so feel free to check that out if you want to. The first thing you need to know about the MCDPA is that it was written to protect residents of the state acting in an individual or household context. In other words, it does not cover commercial or employment contexts. As you might imagine, the law gives Minnesota residents new privacy rights and also creates obligations for both controllers and processors. We'll get into those detailed requirements a little bit later. The main thing to understand now is that a controller is going to be a business that controls personal data and determines how it is to be processed. The processor would be a third-party entity that processes data on the controller's behalf and in concert with the controller's instructions. Just like every other one of these state laws, the MCDPA is completely oriented around the concept of personal data. We have a formal definition here. The MCDPA defines personal data as any information that is linked or reasonably linkable to an identified or identifiable natural person. It then goes on to exclude de-identified data and publicly available information from its definition. This is pretty much a textbook definition of personal data. In fact, it's almost exactly word for word the same as Tennessee's definition. The MCDPA also defines the concept of sensitive personal data. It essentially covers any personal data revealing racial or ethnic origin, religious beliefs, mental or physical health, sexual orientation, or citizenship or immigration status. It also includes biometric data, children's data, and geolocation data. Like with all the other states, Minnesota has special protections just for this sensitive personal data category. One of the most important things about the MCDPA is its applicability thresholds. This law does not apply to every business, and much like the other state laws, it has certain criteria and thresholds which determine whether it applies or not. There's really two criteria which can potentially bring a business under the scope of the MCDPA. First, the MCDPA applies to businesses that control or process the personal data of at least 100,000 unique Minnesota consumers. Second, the law can also apply to businesses that control or process the personal data of only 25,000 unique Minnesota consumers if they happen to derive over 25% of gross revenue from the sale of personal data. Note that there is no pure bottom line revenue filter with this law, like we see in Utah, Tennessee, and even Florida. Each of those states has some sort of annual revenue threshold, which you have to meet before you even start thinking about processing volume thresholds. It's also notable that the law generally excludes small businesses from its scope. Now, this is not a total exclusion. Small businesses still need to obtain consent before processing sensitive personal data, but with that aside, the rest of the MCDPA requirements do not apply to small businesses. There is actually an interesting aspect to this. Texas and Nebraska also exclude small businesses from the scope of their state laws. I believe that these are the only 3 states to do so. But the difference is that Texas and Nebraska do not have concepts of processing or revenue thresholds within their laws. This gets a little bit complicated, and I don't want to get derailed here, but what I'm trying to convey is that Minnesota is the only state that has a small business exemption while simultaneously maintaining an additional processing threshold for all businesses. I think of this as a middle-of-the-road privacy law. It's neither the most consumer-friendly nor the most business-friendly. It's just somewhere in the middle. On a closely related note, we should also be looking at exempted entities. These state privacy laws tend to grant blanket exceptions to certain industries, and there are also certain categories of data processing that usually get a similar treatment. In other words, there's typically some combination of entity level and data level exemptions with these privacy laws. Sometimes that distinction can feel a little bit blurry. As a general rule of thumb, privacy law exceptions tend to be put in place based on the existence of other pre-existing regulations where the lawmakers don't want to introduce conflicts with protections that already exist for certain industries or data types. For example, healthcare providers tend to be at least partially included from these comprehensive privacy laws because HIPAA already governs privacy rules for covered entities and the personal health information that they process. With the MCDPA, we have a bunch of exempted entities and data categories. It's going to be unrealistic for me to rattle them all off in detail, so I'm just going to attempt to summarize. We have exceptions for government entities, federally recognized Indian tribes, financial institutions, and insurance companies. There are also data level exceptions for a whole laundry list of personal data categories, mostly relating to personal health information, other types of medical records and patient information, consumer credit reporting data, and educational data. It's also worth noting that higher education institutions will be subject to the law, but on a 4-year delay. So the MCDPA will go into effect for post-secondary institutions in 2029. If you work in an industry that is traditionally governed by sector-specific privacy laws, I just suggest that you check out the exceptions list. It should help you understand the degree to which this law applies to your business. Also, it's notable and worth mentioning that the MCDPA doesn't have any sort of broad exceptions for nonprofits. This tracks along with many of the more recently passed privacy laws. We're just starting to see this less. There is a very specific exception for nonprofits that are involved in detecting and preventing insurance fraud. These nonprofits are exempt, but for all of the other nonprofits, the MCDPA could apply if they meet the applicability thresholds. Now that we have some sense of who the MCDPA applies to, let's get to what is probably the most important aspect of the law, and that is the consumer rights that it grants Minnesota residents. Minnesota's law introduces several new privacy rights to state residents. These rights are generally similar to those of other states, but the package even includes 1 or 2 rights that we don't see in every state. Minnesota's first consumer right is the right to confirm. You'll sometimes hear this referred to as the right to access. The idea is that individuals have a right to confirm if a controller is processing their personal information, as well as to gain access to that information. There's an interesting little nuance here. There's an exception for trade secrets. Controllers don't have to honor confirmation and access requests if doing so would reveal a trade secret. This isn't completely unique. Some other states have similar exceptions, but again, we don't see it in every single state law. The second right that the MCDPA grants is the right to correct. Individuals have the right to correct inaccuracies in their personal information. Third, we have a right to delete certain personal information. This tends to be a consumer right that comes with some exceptions. For example, a controller may not be obligated to delete aggregated or de-identified information, and there may be legal circumstances where it's not possible to honor the request. Minnesota's next right is the right to portability. Consumers can request and obtain a copy of their personal information in a common and readily usable format. Fifth, consumers have a right to opt out of targeted advertising, profiling, or the sale of their personal information. This is a big right. It's always one worth talking about in detail, so I'm going to dedicate more time to it in just a moment. I'm also going to cover an additional right to question that relates specifically to profiling activity. Before we get to those topics, there is one final consumer right to mention. Minnesota residents have what I'll call a right to disclosure. You might also see this referred to as a right to list or something along those lines. Essentially, it means that residents can request a list of third parties with whom their personal data was disclosed, subject to certain conditions. This is a right that is not explicitly granted by every state. Some other states, like Oregon and Delaware, include something similar in their laws, but not all of the comprehensive laws include this concept. So Minnesota does go above and beyond the average state law in this respect. Okay, so like I mentioned, we need to circle back to that right to opt out. This is a consumer right that has a bunch of different implications, and they can vary between states that may look similar at the surface level. Just like the other U.S. state privacy laws, the MCDPA operates under an opt-out model. To put it simply, the model generally permits the processing of personal data until a data subject decides that they don't want the processing to continue. At that point, if they exercise their opt-out right, the processing needs to stop. Now, there's an important nuance here because there are exceptions for sensitive personal data. When sensitive data is involved, opt-in consent is required upfront. The most obvious and easy to explain example would be children's data. A more stringent opt-in model is required for processing children's data because it's a sensitive category of personal data. Anyway, that high-level right to opt out applies to 3 types of processing: targeted advertising, profiling, and the sale of personal information. I'm going to talk about each one of these separately because there's very important details to share. Let's consider the right to opt out from the perspective of targeted advertising. This one has major implications for websites that rely on advertising technologies, scripts, and cookies. Under the MCDPA, businesses are not outright prohibited from using these tools by default, even before obtaining user consent, as long as they provide a clear and accessible opt-out mechanism. In other words, targeted advertising is generally going to be acceptable under the MCDPA without prior explicit consent, provided that sensitive personal data isn't being processed. The key for businesses is to provide an effective notice about the targeted advertising, as well as an opt-out mechanism that functions correctly and disables the use of targeted advertising. These can both be accomplished with a cookie consent system and a strong privacy notice. Now, I hate to be the bearer of bad news, but there's an important caveat to this whole thing, especially when you think of it from the national perspective. State-level wiretapping laws can still present litigation risks if your web technologies fire without consent. This is especially relevant for analytics and session replay tools. We're starting to get a little off topic, so check out my other videos if you want to know more about that. The key and unfortunate takeaway is that there are unresolved tensions between the newer privacy laws and the case law rooted in older wiretapping statutes. Now, let's consider the MCDPA's right to opt out of certain profiling activities. Let's look at how the law defines profiling in the first place. According to the law's definitions section, profiling means any form of automated processing of personal data to evaluate, analyze, or predict personal aspects relating to an identified or identifiable natural person's economic situation, health, personal preferences, interests, reliability, behavior, location, or movements. This is a pretty broad definition. Now, the profiling opt-out right is a little bit more limited. Under the MCDPA, consumers can opt out of any profiling conducted in furtherance of decisions that produce legal or similarly significant effects concerning the consumer. While we're on the general subject of profiling, it's super important for me to mention that the MCDPA is the first state law to give residents the right to challenge certain profiling decisions, specifically those that carry legal or other significant impact. Residents have the right to question the results of profiling, obtain information about profiling decision logic, and be informed about how they might have secured a different automated decision. Consumers should also be able to review their personal data involved in the profiling activity, and be able to request both correction and subsequent reevaluation if necessary. So, to be clear, we're not just talking about the opportunity to opt out of profiling, which is something that most state laws provide for. The MCDPA empowers consumers much further with this very unique right to challenge profiling decisions. In addition to providing the rights to opt out of targeted advertising and certain profiling, the MCDPA also gives consumers the right to opt out of the sale of personal information. The MCDPA defines a sale as the exchange of personal data for monetary or other valuable consideration by the controller to a third party. The law then lists a variety of exceptions and things that would not be considered a sale. It mentions situations when information is disclosed to a processor, when the sharing is necessary to fulfill a product or service delivery, when personal data is transferred to affiliates, when the information has been intentionally disclosed to the public by the consumer, when there is a merger, acquisition, or bankruptcy, and finally, when there are cooperative provisioning use cases between producers and agents. There were obviously a lot of exceptions packed in there, but they were all pretty standard. The most notable thing about this section of the law is the fact that the MCDPA includes other valuable consideration in its definition of what constitutes a sale. So, a sale doesn't necessarily have to be rooted in the exchange of monetary value. For example, imagine a data-for-data exchange. A business could conceivably exchange specific personal data with a third party in exchange for market insights reporting or something like that. This would be considered a sale in Minnesota. This point is something that the state laws all differ on. Some define the concept of a sale more narrowly and include only monetary payments, and in other cases, like Minnesota's, the law allows for non-monetary value to be considered a sale. In the latter instances, it results in a much broader scope of accountability for businesses. Okay, this takes us to the subject of universal opt-out mechanisms. This is yet another area where the state laws tend to diverge into two high-level camps. There are some states that require businesses to support automated opt-outs for sale and sharing, and there's also several states that do not require this. It's something like a 50-50 split at this point. What you need to know about Minnesota is that it does require support for universal opt-out mechanisms. This is the more privacy-conscious, consumer-friendly category because it gives consumers an easy way to exercise their rights. As far as specific opt-out technologies or standards go, Minnesota has not offered any guidance on which specific automated opt-out mechanisms need to be supported for their law. I can tell you that from the practical standpoint, there's really only one that's relevant right now. That standard is called Global Privacy Control, or GPC. GPC was first developed in 2020. It was created to make it easier for individuals to exercise their privacy rights online. And GPC allows users to configure their browser or a browser extension to send a GPC signal to websites that they visit. The GPC signal is transmitted as an HTTP header or a JavaScript variable. Oftentimes, both signals are delivered concurrently. And GPC signals are meant to inform websites that the visitor wishes to opt out of certain types of data processing. Websites can interpret and respond to the signals in different ways, but GPC is widely recognized as a mechanism for users to communicate a do not sell or share preference. In Minnesota, you need to support automated opt-outs for the sale of personal data and also for targeted advertising. It does not appear that you need to address profiling opt-outs in response to UOM signals, although you do in other states, so it might make sense to do so here too. This is just one of those areas where a consistent approach across the country is usually best, and that could extend to supporting GPC in states that don't explicitly require it. If you'd like more information about global privacy control, we do have another video up which covers it in depth. I've also written some material for the IAPP on the subject. I'll include a link to the article in the video description. If you haven't already done so, this is another great moment to make sure that your consent management system is capable of responding to GPC signals. You may also need to process the signals even more deeply, depending on how you collect and process personal data. In addition to creating a set of consumer rights, the MCDPA also contains several operational requirements for data controllers. Some of these are pretty standard, while others are more unique to Minnesota. One of the most important MCDPA requirements is that controllers provide reasonably accessible, clear, and meaningful privacy notices. As we typically see, the notice needs to contain various important elements. For example, privacy notices need to include information about what categories of personal data are being processed and the purpose behind the processing. They also need to explain the consumer's privacy rights, how they can be exercised, and how responses can be appealed. The notice also needs to convey the categories of personal information that are shared externally with third parties and the specific categories of third parties with whom the personal information is shared. While most of this is consistent with the other state laws, there is an aspect to the notice that is quite unique. If a business is taking part in any activity to which the opt-out right applies, think targeted advertising, sale, or certain profiling, the business needs to provide a method above and beyond the privacy notice that allows the consumer to exercise that right. If this is starting to sound familiar to you, it's because California requires almost the same thing. In California, businesses have to have some specific text on their website that says, "Do not sell or share my personal information." And then a visitor needs to be able to interact with that link to exercise their opt-out rights. You can almost think of this like a manual mechanism for declaring the same type of opt-out preferences that a consumer might deliver with a GPC signal. The requirement in Minnesota is very similar for businesses that are involved in sales, targeted advertising, or certain profiling. Separate from the privacy notice, businesses need to put a link on their website that allows the visitor to easily exercise their opt-out rights. Most businesses will probably stick to the same terminology that they already have to use for California, but the link could also say something like your opt-out rights or your privacy rights. Anyway, this is very important to know about because most of the state laws don't include this requirement for a specific opt-out link that's outside of the privacy notice. In addition to the detailed privacy notice requirements, there are several more obligations that the MCDPA places on businesses. One of these requirements is that businesses must limit the collection of personal data to what is adequate, relevant, and reasonably necessary in relation to the purposes for which such data are processed, which must be disclosed to the consumer. Essentially, what this means is that controllers need to clearly communicate the purposes of their data collection, and they can't go beyond that when collecting data from consumers. You don't want to be over-collecting. In the same theme, the law also requires that businesses not process personal data for purposes that are neither reasonably necessary to nor compatible with the purposes for which such personal data are processed, as disclosed to the consumer, unless the controller obtains the consumer's consent. The second part of that legalese prevents companies from moving the goalposts. Unless you have consumer consent, you can't change how you process personal data after you've communicated and collected it in the first place. The law also includes a retention requirement. Businesses cannot retain personal data for longer than it's relevant or for longer than necessary to execute on the original purposes for which the data was collected. There are obviously exceptions here for situations where data needs to be stored longer for legal reasons and things like that. All of these elements are very consistent with our other state laws. They all tend to include these concepts of purpose and processing limitations. Like many other states, Minnesota's new state law contains data protection requirements. Controllers are required to establish, implement, and maintain administrative, technical, and physical data security practices. These practices are required to protect the confidentiality, integrity, and accessibility of personal data. They almost got the CIA triad right. I wish they would have called it availability instead of accessibility, but whatever. Just like most other privacy laws, this is a very high-level requirement The law is not going to tell you much about how to implement your cybersecurity and data protection program, with one exception. What is super unique to the MCDPA is a requirement surrounding data inventory. Businesses need to maintain an inventory of personal data for which they will be applying data protection controls. This makes a lot of sense. You can't protect data or assets that you don't know you have. There's a reason that inventory controls are usually the first topic that gets addressed in most cybersecurity frameworks. Anyhow, the interesting thing is that Minnesota requires the maintenance of data inventories explicitly. It is the first state to include this in their comprehensive privacy law. The next MCDPA controller requirement has to do with data subject consent for processing. I touched on the concept earlier, but I want to reiterate. Processing sensitive personal data under the MCDPA requires explicit consent. This aligns with the standard model for U.S. state privacy laws and applies to categories of data like biometric data, children's data, and precise geolocation data. If a business is processing any categories of sensitive personal data like this, it needs to follow the opt-in consent model and obtain that consent up front before processing occurs. Similarly, if an organization is performing targeted advertising or selling the data of consumers between the ages of 13 and 16, consent is needed for that. For individuals under 13, compliance must align with the Children's Online Privacy Protection Act, which has separate requirements of its own. Additionally, the MCDPA requires that consumers have the ability to revoke consent at any time. If a consumer withdraws their consent, the controller must cease processing the affected personal data. The revocation process should be just as easy to exercise as the initial consent mechanism. Businesses must also inform consumers of their right to revoke consent within their privacy notice. We also have a pair of MCDPA controller requirements that have to do with non-discrimination. First, businesses are prohibited from using personal data in ways that unlawfully discriminate against people based on their protected characteristics, like race, religion, gender, or disability, especially when it comes to areas like housing, jobs, credit, education, or access to public services. Second, and on a slightly different note, businesses cannot punish someone for exercising their privacy rights in Minnesota. That means that you can't deny services, raise prices, or reduce quality just because somebody made a data subject rights request. Another aspect of the MCDPA that controllers need to address is a requirement to perform data protection assessments before conducting certain types of processing activities. This is similar to most of the other state requirements. The assessment requirements tend to activate in situations where the business is involved in data processing for the purpose of targeted advertising, certain profiling, or sale of personal data. Assessments are also required when a business processes sensitive personal data or processes data in a way that presents a heightened risk of harm to consumers. The idea behind these assessments is that they need to weigh the risk of processing personal data in certain ways to make sure that the risks don't exceed the benefits of performing the processing in the first place. These assessments need to be retained for at least 5 years and made available to the Minnesota Attorney General if requested as part of a regulatory inquiry. One topic that I didn't have a chance to get into earlier was data subject requests. If an individual in Minnesota wants to exercise their privacy rights that we covered previously, companies need to respond to the request and fulfill the ones that they're obligated to fulfill. Remember that there are some circumstances where businesses can deny requests. For example, there may be legal obligations that prevent a business from fulfilling requests, or the request might be out of scope, perhaps involving anonymized data, or something along those lines. Generally, Minnesota's law requires that companies respond to consumer requests within 45 days with the possibility of a one-time 45-day extension. That time frame is pretty standard across all of the state laws. The law also requires that controllers establish an appeals process for consumers whose requests are denied for one reason or the other. The appeals process must allow for appeals within a reasonable period. The organization must inform consumers of the denial reason and respond within 45 days by default. If denied on appeal, the business must also instruct the consumer how they can contact the Minnesota Attorney General. Before we move on from the controller requirements, there is one more thing I want to cover. One very unique aspect of the MCDPA is that it requires companies to assign a chief privacy officer or appoint someone to a similar role with the responsibilities of managing the documentation set necessary to comply with the MCDPA. The big idea is that there needs to be a specific individual who is accountable for MCDPA compliance. Subsequently, the individual that's been assigned to this role needs to maintain documentation surrounding the policies and procedures governing MCDPA compliance. The documentation needs to describe the privacy official's contact information, compliance policies, data inventory controls, retention policies, details about how new systems are evaluated for compliance, and details about mechanisms to detect and remediate violations. All of this documentation must be available to the Minnesota Attorney General under certain conditions. Now that we've discussed many different controller requirements, I should note that the MCDPA does place some requirements on processors. The MCDPA requires processors to assist controllers with their MCDPA compliance obligations. This could mean that the processor needs to follow instructions provided by the controller or help them with various obligations, like responding to consumer requests and providing information that's needed to perform accurate data protection assessments. There's also a requirement that controllers and processors establish contracts with one another. These contracts need to outline processor requirements, like maintaining the confidentiality of personal information and properly deleting or de-identifying data when appropriate. They also need to include provisions to ensure that subcontractors meet the same obligations as the processors, and that privacy compliance activities can be audited or inspected across the supply chain. Essentially, these contractual terms help ensure that processors are supporting the controller's compliance efforts under Minnesota's privacy law. Okay, we've covered just about all of the main requirements of the MCDPA. Let's turn our attention towards enforcement. The MCDPA is going to be enforced exclusively by the Minnesota Attorney General. Like all the other state laws outside of California, there is no private right of action here. The Minnesota AG will be leading the way on enforcement in situations where they believe that a business is violating the law. Like in Tennessee, Minnesota's new law does include a cure period, which will allow businesses to resolve their issues before being penalized. However, Minnesota is not quite as generous to businesses as Tennessee was. For starters, the Minnesota cure period is only 30 days long. That's half the amount of time that Tennessee provides. Even more notably, the cure period is going to sunset after only 6 months. By the end of January, the cure period will be gone, and businesses will no longer have the opportunity to fix their mistakes before being subjected to penalties. This is another pretty good example of Minnesota taking the middle-of-the-road path. This is not a generous cure period, but then again, some of the state laws don't even have cure periods in the first place. When it comes to penalties, the Attorney General is going to be able to penalize businesses at $7,500 per violation, along with additional fees and costs. This is super typical when it comes to these types of privacy laws. This is the most common penalty structure we see across all the states. Okay, thanks for sticking with me through all that. I know it was a lot. I hope that you're feeling good about the Minnesota Consumer Data Privacy Act and that you have a good sense of what you need to do to comply. If you need help making sure that your company is in compliance with the MCDPA, Captain Compliance is right here and ready to help you. Our cookie consent banners are fully customizable to match the design of your website, and they can be set up to apply different policies to different visitors based on their region. So, for example, you might choose to apply an opt-out policy to visitors from Minnesota while applying an opt-in policy to visitors from the European Union. Our dynamic privacy notice also has a localized and geographically targeted Minnesota supplement ready to go. If you're already a Captain Compliance customer, the new Minnesota disclosure is already available to you, and if you're using automatic updates, the disclosures are live. If you need help, please feel free to visit our website. It's www.captaincompliance.com. I'll put the link as well as additional contact information in the video description. Thanks for watching.